Morning, everyone. This is Kristen O'Neill. We'll get started in a minute or two. I'm just getting my screen set up, and we'll give everyone till at least 10 o'clock or 10:01 to join us, and then we'll get started. Thank you. Morning, everyone. This is Kristen O'Neill with the Committee on Open Government. We're going to be here to do an overview and update on the world of freedom of information law. Just a little bit of a housekeeping. If anyone wouldn't mind, I just want to make sure hey, I'm really terrible sometimes about using multiple screens when I'm trying to share something. Would someone mind putting a note in the system reflecting whether they can see my PowerPoint in a way that seems like a full screen version of the PowerPoint? I just want to make sure that it is showing correctly on your end because I can't quite tell. Good morning, everyone. I'm not sure if I just did a quick introduction, but I'm not sure if it went through. I feel like I'm having a little bit of a technical difficulty. Would someone mind sticking a note in the chat function and letting me know whether if you can hear me, just let me know. And if you can see my PowerPoint, that would be helpful as well. Thank you, Evan. I did get a note saying that I'm on now, but I think maybe that for some reason my first go around didn't work very well. I really appreciate it. I'm sorry, you can see in here, so everyone is answering my questions. I really appreciate it. Sorry for asking you to be my tech support, but there we go. So anyway, so here we are today. We're going to do an overview and update on the Freedom of Information Law. And what we will do is sorry, I'm pulling up. I apologize. I'm being a technical dummy right now. Close that out. what I ask is that if people have questions as we go along, if they wouldn't mind putting them in the chat feature. So even if you have a question, if it turns out that I get to it later in the program, we can talk about that. But I don't want you to forget. So what I'll do is I will have you put questions in the chat feature, and maybe I'll take breaks periodically throughout the program and switch over to the chat feature and take those questions. And then certainly at the end, anything that I don't get to that we don't cover, I will certainly cover by going through the chat feature. So that's where I'm going to have you put any questions that you have about what we're talking about today. So let's see. This is my contact information. The Committee on Open Government, for those of you that aren't terribly familiar with us, we are housed within the New York State Department of State. That's where our staff is. And our staff is made up of Shoshana Boulay is our executive director. There's myself, I'm the deputy director and counsel. We have senior attorney Kristen Smith. We have our Excelsior fellow Miguel Carlo Batista. We have an administrative analyst who just started with us recently, who's going to be doing some work with us to try to help us organize and update the information that's available on our website, specifically relating to the advisory opinions, try to get them modernize the access a little bit. That's our goal. Some of the information, there's a lot of great information out there in the advisory opinions. We just want to try to make it easier for people to be able to find that information. And then we have our administrative assistant, Candace Watson. So that's the entire staff of the Committee on Open Government. But we're an open resource. Anyone that has questions regarding FOIL, the open meetings law, or for at the state agency level, the personal privacy protection law, anyone's welcome to contact us with questions about those statutes. You can call us at that phone number, maybe ask to speak with an attorney, or you can email our office account, which is the COOG, C-O-O-G, @dos.ny.gov, and shoot an email, and the first attorney that has an opportunity to do so will get back to you. We do really try to be cognizant of the fact that your questions are time sensitive often, and we don't let things sit for long. If you give us a call, the likelihood is if we don't take your call right that minute, we're going to get back to you very quickly. If you feel like you've waited too long, don't hesitate to give us a nudge, because maybe something fell through the cracks and we don't want you feeling like you're waiting for an answer that you really need. So we really do try to take into consideration that people's questions about open government statutes often tend to be time sensitive. So we're going to keep that in mind. Our website is www.opengovernment.ny.gov, and they're on that website. Pull it up here. This is what it looks like generically. There's a lot of helpful information on the website. So at the top of the screen, you'll see sort of that teal bar, and if you hover over Freedom of Information Law, you're going to see that you can access a copy of the statute, the regulations, the advisory opinions, the case law summaries. Same is true for open meetings law. When we have meetings of the Committee on Open Government, which we're actually having, we'll have a couple right now. We're required by law to have at least two. Those generally tend to be in the fall, because we have an obligation under the statute to issue a report to the governor and the legislature with an update on the activities of the Committee on Open Government, but also with recommendations for any amendments to the statute we'd like to see occur, that we've heard from our experience from the public and from the government agencies, some recommendations for amendments to the statute. So that is due to the governor and the legislature every year on December 15th. So we're working on that now. And then anytime there's anything new and exciting in the world of open government, you're going to see it right here on our website. If there's any amendments to the statutes, we will try to get that up front and center. So if you've heard rumblings about an amendment, a good thing to do is go right to our homepage on our website. Oftentimes we'll have information on either that large banner where you see a picture of the Capitol, or the white smaller banner. So look to those places, and that's where you often will find the most updated, or excuse me, the newest happenings in the world of open government. So the Freedom of Information Law is celebrating its big 5-0 this year. It was enacted in 1974, but that version was fairly limited in scope. It gave the public access to 9 categories of records, and if you couldn't find the type of record that you were looking for on that list, you were somewhat out of luck. That was repealed and replaced with the current version in 1978 that is based on a presumption of access. So what does that mean? Every agency that is subject to FOIL should, when receiving a Freedom of Information Law request, should start with the assumption that all government records are public, that they're going to be required to be disclosed, unless the agency can review those records and determine that the record itself or any portion of the record fits into one of the permissible grounds for denial. Who is covered by FOIL? FOIL governs access to agency records. The term agency is what is used in the statute, and it's defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or for any one or more municipalities thereof. So, of course, we have government at the state level. You have agencies under the governor's office at the executive branch, Department of State, Department of Health, Department of Labor. Those are all agencies subject to FOIL. Then you have the Office of the Attorney General, the Office of the State Comptroller that are separately elected positions, but those entities are also agencies subject to FOIL. And then you sort of work your way down the municipal level. You have counties and cities and towns and villages and school districts, public libraries, water districts, sewer districts. There's so many, there's thousands and thousands of units of local government in the state of New York. So there are many, many FOIL responsible entities in the state of New York. Who's not subject to FOIL? The judiciary. The judiciary is completely exempt from the requirements of the Freedom of Information Law. So if you want to obtain records from any court, whether it's a town or village court or a Supreme Court, Freedom of Information Law is not the appropriate mechanism for obtaining those records. There are statutes, New York State judicial law, judiciary law governs access to those records, and many of those records are public. It's just that FOIL isn't the mechanism for obtaining them. And FOIL does govern access to state legislative records. However, the state legislature is not an agency, as that term is defined in FOIL. So when you're looking to try to obtain state legislative records, it's much more limited in scope. It's very similar to that original 1974 version of the statute. Here's a list of the kinds of records you can obtain. And if it's not on that list, you're out of luck. Every agency subject to FOIL has to have a records access officer. So the position of records access officer is established by regulations, by the regulations promulgated by the Committee on Open Government. It's not actually mentioned in the statute, but at some point I think it was deemed necessary to let agencies know that they need to have somebody responsible for being the point person for receiving FOIL requests. So it was established by regulations promulgated by the Committee on Open Government. And those regulations state that the governing body of an agency, or the governing body or the head of an agency, has to be responsible for ensuring compliance with the law and the regulations. So keep that in mind, that the records access officer for an agency is certainly not the only person or persons responsible for complying with FOIL, for making sure that an agency meets its responsibilities under the Freedom of Information Law. They are simply the point person, and I don't mean that to minimize it. It's a big responsible position, but certainly they shouldn't feel the entire responsibility of FOIL on their shoulders. They are the point person, and then that point person, who is designated either by name or by job title, has the responsibility of reaching out to the appropriate staff, the appropriate program areas, and gathering the records. The records access officer is going to be responsible for ensuring that the agency meets its statutory time limits for responding. So essentially, as I said, point person, but not the only person that has obligations under the statute. The records access officer by policy has to be designated by name or by job title. There has to be a business address where FOIL requests can be received and an email address where FOIL requests can be received. Records. What is a record? Under the Freedom of Information Law, the term record is defined incredibly broadly, much broader definition than, for example, the New York State Archives uses. Record means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then the statute gives a non-exhaustive list of examples. It's contracts, it's meeting minutes, it's video, it's audio, it's data maintained in a database, it's email sent between or among employees, regardless of how innocuous they might seem. You can send your emails a coworker saying, hey, would you like to go out for a drink after work today? And you've thereby created a record that is subject to rights of access under the Freedom of Information Law. Now, when I say something's a record, I'm not saying that it's something that definitely needs to be disclosed. I'm just saying that it is something that is subject to rights of access under FOIL. You need to at least consider and go with that presumption that it is a record that the public is entitled to, and then you can look to see whether the statutory grounds for denial apply. Under FOIL, an agency is not required to create records. FOIL does not obligate an agency to answer questions or to manually create a new record in order to provide information. So if an agency receives a FOIL request and says, I really don't understand why you made this decision, I want you to provide me an explanation as to why you made this decision. That's not a FOIL request, that's a request for information. And an agency is under the Freedom of Information Law not required to answer those questions. As public officials, I think many of us, I think quite a few people that are on this program today are public officials, and we answer questions all the time. Oftentimes it's part of our job responsibilities to answer questions, but that doesn't mean it's something that you're required to do under the Freedom of Information Law. Making a copy of an existing record does not constitute creating a new record. Sometimes this might seem like common sense, but sometimes there's little quirks that make it confusing. So for example, I think the most common thing that we think of, even though it's a little bit old school at this point, is photocopies. Someone makes a Freedom of Information Law request for a contract and they want a photocopy. Yep, you're required to make a copy of that, and that's not creating a new record. But in addition, if someone would prefer that those records be provided to them in an electronic form, and for some reason you don't already, as an agency, possess them in electronic form, but you do have the ability to scan them using your multifunction copier scanner, then you would be required as an agency to scan those records and maybe email them or provide them in some sort of electronic storage device if they're too large to be sent by email. That's not creating a new record. Making a copy of an existing record, regardless of the format that you're making that copy in, is not creating a new record. Extracting data from a database is not creating a new record. So first, an agency is required to provide records on the medium requested by a person. So for example, if someone wants an Excel file, a document that was originally created in Excel, and they want that original Excel file, an agency is required to provide that original Excel file. Sometimes agencies would have a preference for sending out the record in a non-editable format, like a PDF. Maybe they've printed it out and scanned it, or they've just printed it to Adobe, to PDF, so that it can't be edited. If the person who's making the request doesn't want that, if they want it in the original format, like Word or Access or Excel, the agency has an obligation to provide it in that medium. When an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, the agency is required to do so. And that is not to be deemed to be the preparation or creation of a new record. I'm just going to take a quick break, and I know I saw a couple of chats come in, questions come into chat. Let me see. I feel like I'm always struggling with this a little bit. It disappears when I'm on. I saw it come in. All right, well, I'll talk while I'm finding it. There are 3 records that an agency is required to maintain, create, maintain, and make available when under the Freedom of Information Law. Those 3 records are: the first is a record of votes of each member in every session and every committee and subcommittee meetings in which the member votes. So if you have for example, a town board, and under the Open Meetings Law, which we'll talk about this afternoon if you'd care to join me, not required to, but if you'd like to, we're going to do Open Meetings Law this afternoon. So this morning, under FOIL, there's an obligation to maintain a record of how each member votes. Open Meetings Law only requires that you have a record or summary of any resolutions, motions, anything that's formally voted on, a record summary of what's being voted on and the results of the vote. So if you have a 5-member town board, those minutes could merely state that a motion passed for 5-2. Under the Freedom of Information Law, there's a statutory obligation to show how each individual member voted. All right, so let's see. Go back into my chat. Oh, my helpful people letting me know they could hear me. Sorry, no, I'm just kidding. Everybody was very helpful letting me know they could hear me, so I'm just trying to scan that. One person asked, which is a good question, will the PowerPoint slides be available? And the answer to that is yes. I have versions of PowerPoint already available on their website. So if you go to opengovernment.ny.gov, there's a portion of our website that says, I would like to view training materials and recordings. And if you click on that link, it's going to bring you to PDF copies of these PowerPoints, as well as recordings. It's a link to our YouTube page where recordings of previous programs, just like this one, are posted. I am recording this program right now, and I'm going to ask our IT staff to post it to that same YouTube page. So if you have colleagues that maybe wanted to sign on to this but didn't have the ability to do so this morning, it will be available on our website. So that's where the PowerPoints are available on the website. The next question is, are the police considered judiciary? And the answer is no. Judiciary are the courts, town courts, village courts, city courts, county courts, Supreme Court, Appellate Division, Court of Appeals. That's what the judiciary is. The police are considered an agency just like any other. Someone's asking whether it's going to be recorded and can be watched later. The answer is yes. You can go right to it. Will be available hopefully by the end of the week. No later than the end of the week, I'll have it posted up on the website. Does the records access officer information need to be published on the website, just be available when the agency is contacted? This is a good question, because for state agencies, it's required to be posted on the website. For local agencies, I really do highly encourage it, but it's not a statutory requirement that the information be posted on the website. As I said, I really do encourage local government agencies to put their FOIL contact information on their website. I think it makes life a lot easier for everyone, but it's not a statutory requirement. Someone's asking about, we have a lot of residents asking for copies of our maps. Does that require me to go to a print shop and give them a copy of a large map, or does that mean I'm creating a new record? That is not creating a new record. That's merely making a copy of an existing record. I'm going to talk about fees later, about what you're allowed to charge for when you're being asked to make a copy of a record that's sort of in a non-traditional format. We'll talk about that later, but that is not creating a new record. That is just making a copy of an existing record. Another question that has come in says, if a FOIL is first sent to another department instead of directly to the FOIL officer, how should that be handled or regarded? My practical advice is that your staff should be made aware that if they receive a FOIL request, they should immediately forward it to the records access officer. That's my practical advice. Do planning boards need to record records of voting by individual members? Yes, they are subject to that provision that I just mentioned, where there's a record. There has to be a record of votes of each member in every session and every committee and subcommittee in which the member votes. That applies to planning boards. Yes, you have to have a record of how each member of the planning board voted. Someone's asking, if a request is made for over 13,000 records, which will need to be downloaded from a database onto a thumb drive and will take an extensive amount of time, can we charge? I'm going to talk about fees later, what you are and are not allowed to charge for. Does this mean that committee meeting votes also need to be roll called? Roll call is done on these actions at the board meetings. You have to have a record of how each member voted, I guess is the short answer. I'm not sure how else you're voting, whether it's by, I mean, as long as you know, as long as whoever is making records knows how each member voted. Sometimes it's a matter of, all in favor, all against, and that's how it's done, not necessarily calling each person's name and asking them how they voted. You just have to know, based on the meeting, how each member voted, so that can be recorded in writing. When a requester asks for emails between agency employees and after review, we find that there are no exemptions that require redacting the emails. Can we provide the emails as PST files? If the person isn't, you can provide them in a format that would be generally accessible to anyone that asks for them, unless they've specifically asked for a specific format. If they ask for a specific format and you have the ability to provide it in that format, that's what you should be doing. But otherwise, you just want to make sure that you're providing the copies of the records in a format that would be generally available to anyone that asked for it. Like, you don't want to use some sort of specific program that maybe only your agency uses. What's the best way to handle a request from a different department? We don't have access to the records and they have been taking almost 2 years to give us anything. If you're the records access officer, I mean, honestly, this is an internal question as opposed to a legal question, and you need to get supervisors and heads and governing bodies involved. Everyone needs to understand, every employee of a government agency needs to understand that they have an obligation under the Freedom of Information Law. Ultimately, if the agency doesn't respond to a request, there are provisions built in that allow an applicant to treat that as a denial, which I'm going to talk about more. But in terms of internal processes, people have to be educated. Employees of government agencies have to be educated and understand what their obligations are under the statute and what they're exposing their agency to if they fail to meet those expectations and obligations. If you're a town clerk, that's just one example. Town clerk is a good example because the town clerk, under New York state law, is the legal custodian of all town records. So when, sometimes I hear from the town clerk, oh, I don't have access to those records. And I say, you're the legal custodian of those records. So whether they're sitting in your office or not, they're your records, and the other departments have an obligation to get you those records. We're going to talk about fees later, so a couple people have asked about fees. I'm going to skim past those because we are going to get to that. When you're asking, a couple of people are starting to ask me with questions about rights of access and what can be denied. That's, obviously we're early on in the presentation and I haven't gotten to that yet. So we'll get to those questions. I think the second record that every agency is required to maintain is a record setting forth the name, public office address, title, and salary of all of its employees and officers. The third record that every agency is required to maintain is a current list, reasonably detailed by subject matter list of any records required to be made available under FOIL. Many municipalities adopt the LGS1, the Records Retention and Disposition Schedule established by the New York State Archives, as their subject matter list. For larger agencies, like at the state level, state agency, that might be a jumping off point, but there's probably going to be more detailed subject matter list that a state agency would need to create and maintain and make available. State agencies are also required to have their subject matter lists available on their website. When an applicant makes a request for records, they are required to put that request in writing if the agency wants them to put the request in writing. And two, they have the, I think I said A and two, I like that. A and B, or 1 and 2, they have an obligation to reasonably describe the records sought. What does that mean? Has the applicant provided sufficient detail to allow the agency to identify what record is being requested? And second, have they provided enough detail or the correct details to allow the agency to locate or retrieve the record with reasonable effort? And part of this depends on how the agency maintains its files, maintains its records. If you have filing cabinets where records are all maintained alphabetically by last name, if somebody provides only a first name, that's not going to be particularly helpful, and the agency is probably going to be able to deny the request based on the fact that they are not able to locate or retrieve the record with reasonable effort. Agency is not required to conduct the proverbial search for the needle in the haystack. Of course, it's a lot easier to locate records when they're maintained electronically. It's a lot easier to do electronic search for records than it is for paper, searching paper records. But certainly, it often depends whether an agency can find the record with reasonable effort, can locate and retrieve the record with reasonable effort, is going to depend on the record keeping system. Time limits. When an agency receives a FOIL request, they have to do something within 5 business days. They either have to provide access to the record sought, deny access to the record sought. They can state, we do not possess the record sought, or we cannot locate the record sought after a diligent search. I want to point out that that is not a denial of access. That's 2 different things. Denying access and stating that we do not possess the record sought are 2 very different things. I guess from a common sense standpoint, you can understand that if you tell somebody that you don't have something, you're not denying them. You're just telling them that I don't have what you're looking for. I can't give you what I don't have. But that is that's sort of a different response than a denial of access. The fourth option is an acknowledgement of receipt of the request and a statement by which you plan to respond. So within 5 business days, if you can't fully respond to a simple request, for example, sometimes if you're a small agency, or if it's a very simple request, you're just going to be able to turn it over within that 5 business days. But the larger the agency or the more complicated the request, the more likely it is that you're going to send an acknowledgement letter acknowledging receipt of the request and telling the applicant when you plan to respond. You need to provide an approximate date by which you plan to respond if you're the agency that is reasonable under the circumstances. If you need more than 20 business days from the date of the acknowledgement, you need to provide a reason for the delay, and you need to provide a date certain by which you plan to respond. While the courts don't necessarily agree with the Committee on Open Government on this point, it has always been the opinion of the Committee on Open Government that agencies should not be engaging in repeated extensions. our belief is, if you look at the statute and what the intent of the statute is that agencies should be evaluating those requests at the time of receipt. You have time to evaluate. You have time within the first 5 business days to evaluate the request. Then on top of that, you have another 20 business days to acknowledge the scope and complexity of the request. Once you hit that deadline as an agency, if you cannot fully respond within that first 25 business days, you should at least have the ability to identify a date certain that you plan to respond by that is reasonable under the circumstances of the request. Maybe this is 3 months out, maybe this is 6 months out, maybe it's a year out. Agencies have the ability under the statute to take that additional time as long as the time is reasonable given the circumstances of the request. I highly encourage agencies to take this approach as opposed to the approach where an agency keeps just bumping it out month after month after month with no end in sight. That's very frustrating to an applicant to think they're going to get a response in a month, only to find out that there's really no clear intent to do that. What the agency wants to do is explain to the applicant, listen, you've asked for a lot of stuff, and we really need, this is how much time we need to process this request. Or you are one of the 5,000 FOIL requests that we are currently processing, and this is how much time we need. Let the person know. Sometimes, especially if it's a person who's making a very large FOIL request, they may be willing to modify the scope, narrow the scope of their request if they understand that processing the much larger request is going to take a significant amount of time. When there's a denial of access, an agency is required, or excuse me, an applicant has 30 calendar days to appeal that denial. When the agency receives the appeal, they have 10 business days to respond to the appeal. All agencies must accept requests via email. An agency cannot require a requester to use its own form, and this includes electronic forms and portals. So any state agencies that I've got on my program here today, in our opinion at the Committee on Open Government, we all have GovQA at state agencies, or at least we're moving in that direction if we're not all there yet. We have GovQA as a tool, and it's, it can be a very helpful tool for monitoring and keeping track of Freedom of Information Law requests, and the public may enjoy that tool because they themselves can use it to submit a FOIL request easily. But as a government agency, you cannot require that an applicant use your own paper form or electronic forms and portals. As long as they put their request in writing, either on paper or via email, they've done their jobs. And this is also my selling point to agencies that only have portals but do not have email address. In our opinion, the law requires that an agency have an email address where they accept FOIL requests, not just electronic portals, email address. So all agencies should have an email address where they can receive FOIL requests. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. If someone wants to submit a FOIL request under janedoe@gmail.com and they are asking for a record that would be publicly available to anyone that asked for it, they should be permitted to remain anonymous. All right, I'm gonna go back and see questions. If a clerk doesn't get a response from board members for FOIL records, is it appropriate to say that there was no response and assume no records exist? No, that is not the best way to handle that. You want to get confirmation. If you are going out to program areas or particular staff or officials, as if you were the records access officer and you have reached out to either specific staff, specific program areas, particular departments, whatever the case may be, to find out if they have records that are responsive to the request, I would certainly not treat a non-response as some sort of confirmation that there are no records. You, as records access officer, I would want something in writing or by phone confirming affirmatively stating that they do not possess any responsive records. Because as records access officer, if you are responding to the applicant stating there are no responsive records, they have a right, as we're going to talk about later, to request that you certify to that. I wouldn't certify as records access officer that I don't possess responsive records based on a department or staff member's failure to respond to my inquiry. So the answer to that is no, that's not appropriate to assume no records exist under those circumstances. Is it reasonable to ask for 10 months of board member emails pertaining to a list of items? That's going to be very specific. I don't want to give a general answer to that. It's going to depend on the specific facts, and that's something that I encourage you to reach out to us directly about. When you get, as if you're a person if you're the one receiving the FOIL request and you're not sure if this is something where the courts might weigh in and say this goes beyond the scope of what FOIL intended, because there is some case law to that effect. It's going to depend on the very specific factual nature of what is being requested. Another person goes on to state this: we currently had a FOIL request that was extensive. When we acknowledged the request, we cited that the request was voluminous and would be available on a specific date, and the requester took that as a denial. What the person has the right to do is disagree with the reasonableness of the date that you provided, and that is deemed to be a constructive denial of access. So they were permitted to treat that as a constructive denial of access. Our regulations, the Committee on Open Government's regulations, give a list of situations that trigger that constructive denial of access. And one of those things is when the applicant disagrees with the reasonableness of the amount of time the agency has stated it needs. When the FOIL appeals officer receives that appeal, the FOIL appeals officer has an obligation to then do a review and determine whether, in fact, the amount of time that the agency has stated it needs to respond to that request is reasonable. If you agree with the reasonableness, then that's what you tell the applicant. At that point, they have the right to bring an Article 78 proceeding in state Supreme Court if they still disagree. But otherwise, you keep going on and processing the request. Someone just asked a question that it was very similar to the earlier one. Can a requester file a constructive appeal if the time you sent seems to be too long for them? The answer is yes. Next question is, we received a request about staff union membership a couple of years ago. We were told by the rep that it was against the law to give any information about a collective bargaining member. I'm not aware of any state statute that prohibits disclosure of union membership information, but if the person, whenever you have someone telling you something's against the law, the first thing that you do is ask them to provide a copy of the law. That's what you do. If someone says, you are prohibited from disclosing this information, it's illegal, it's against the law, tell them, give me a copy of the law and be happy to review it. That's what you do. I replied to a FOIL request stating that certain wording in 1980 town board minutes do not exist. He responded that he wants to come in and personally look at the minutes himself. Every applicant for records has the right to inspect original records that would be available in their entirety. So if you have your 1980 town board minutes put in a big binder somewhere, they have the right under the statute to come in and inspect those meeting minutes. All right, we'll move forward a little bit. Next, we're going to talk about the permissible grounds for denial. Got a couple of screens up here. Again, don't feel like you have to memorize. All this information is available on our website. We have a publication called Your Right to Know. The PowerPoint slides are available on my training portion of my website. All this information is available on the website, so don't feel like you have to memorize it all. So I've got two screens here. There are other grounds for denial that relate to provisions of vehicle and traffic law, like red light cameras, school bus cameras, things of that, speeding cameras, things of that nature. Doesn't come up that frequently, but if your law enforcement unit within your agency receives a FOIL request for something that involves a provision of vehicle and traffic law and your ability to take images, recordings of cars, you're going to want to look to those vehicle and traffic law provisions. But otherwise, as I said, they don't come up that often. So we'll talk about the ones that do come up frequently. The first is when a record is exempt from disclosure by state or federal statute. Under the Freedom of Information Law, FOIL doesn't prohibit disclosure of any record. The Freedom of Information Law itself does not prohibit disclosure of records. What it does is it states you presume that all records are available, and then as a government agency, you can elect to assert one of the statutory grounds for denial, such as unwarranted invasion of personal privacy, or intra-agency material, or law enforcement where disclosure would cause harm. Again, we're going to talk about those, but those are permissive. They allow an agency to assert those grounds for denial, but they don't require. When a record is exempt by state or federal statute, it's not really FOIL itself that's prohibiting disclosure. It's the separate state or federal statute that's prohibiting disclosure. So if access to a particular record is governed, for example, by the attorney-client privilege, if you have communications between a town board and its town attorney, or Department of State staff and its counsel's office, if you have communications where you have individuals that are requesting legal advice from their legal counsel and their attorney is responding by providing that legal advice, those communications are exempt from FOIL disclosure under New York State civil practice law and rules, and it's commonly known as the attorney-client privilege. Another example is school districts are subject to the Freedom of Information Law. Community colleges, SUNY, CUNY, are all subject to the Freedom of Information Law because they're government agencies. However, you cannot make a Freedom of Information Law request for another child's student education records, or even another adult's student education records. So, if you're annoyed by the kid down the street, you can't, see if you can dig up dirt on them by making a FOIL request to the local school district for copies of their education records. Those records are confidential by federal statute, the Family Educational Rights and Privacy Act. I used to be the records access officer for the Office of Mental Health. More frequently than you would think possible, I would receive FOIL requests for, I would receive FOIL requests for copies of people's psychiatric records. And to be honest, that was not any of my business as records access officer or as a member of counsel's office, whether a particular person had ever spent time in one of the New York State public psychiatric institutions. So I never even asked. If someone said, I would like a copy of, Jane Doe's psychiatric records when she spent time at Kingsborough Psychiatric Center, my response would have just been to explain that those records are completely exempt from FOIL disclosure by state statute and by federal privacy regulations. I was never going to go to Kingsborough Psychiatric Center and ask them whether they had that record or not. Autopsy records are confidential under New York State county law. Recordings, transcripts, other records of calls made to a county-operated E911 system are confidential under the New York State county law. If you have a record that contains an individual's social security number, you're going to want to make sure that you're always redacting that social security number. So those are just a few examples where a record is completely exempt from disclosure under the Freedom of Information Law. And again, while it's not FOIL that's prohibiting disclosure, as a government agency, the government agency has an obligation to comply with that separate statute. And if that separate statute prohibits disclosure, then you want to make, 100% going to need to comply with that separate statute. Unwarranted invasion of personal privacy is one of the common permissive grounds for denial. I say it's permissive except for state agencies. If you are a state agency, if you're the records access officer of a state agency, or if you're making a freedom of information law request to a state agency, you should keep in mind that there's another statute, the New York State Personal Privacy Protection Law, that prohibits an agency from disclosing records when disclosure would constitute an unwarranted invasion of personal privacy. On the other hand, if you are a records access officer for a local government or a school district or anything that's not a state agency, the Personal Privacy Protection Law does not apply. So it does not apply to records maintained by any local government agency, doesn't apply to school district records. So the ability to rely on withholding records on the ground that disclosure constitutes an unwarranted invasion of personal privacy, it's permissive. A local government agency is permitted but not required. A state agency is required. Some examples of where disclosure would constitute an unwarranted invasion of personal privacy. Sometimes you have a job opening. As a public government agency, you have a job opening and you have 20 people who apply for that position. The person who's hired as a public employee is going to enjoy a lesser expectation of privacy than other individuals. So information about the individual that was chosen and ultimately hired by the government agency, there's a good amount of information that's going to need to be disclosed upon request about that person. So for example, if someone wants a copy of my resume, I'm an attorney with the Department of State. If someone wants a copy of my resume, they're entitled to see a good chunk of my resume that reflects my previous public employment, the fact that I have a Juris Doctor from SUNY Buffalo. I know, very impressive, right? So, no slam on SUNYs. I love my SUNY Buffalo law degree. The fact that I am a licensed attorney, that I'm admitted to the New York State Bar, those are all things that the public is entitled to know about me, to know that I am qualified for the job that I have. On the other hand, if you have people that applied that were not chosen, any information that reflects the identity of that person can be withheld because you want to protect their privacy. You don't want to throw them under their bus with their current employer. You want to make sure that they can apply for jobs without everyone knowing that they're applying for another job. Home telephone numbers and personal cell phone numbers can be withheld. Medical information, whether it's about a member of the public or about your employees. And here I'm not talking about medical information that would be covered by HIPAA. So for example, we have public hospitals. As I mentioned, OMH has its own hospitals, but not just psychiatric mental health hospitals. We also have public hospitals that are city operated, county operated, and those medical records maintained by those healthcare providers are confidential by statute under the Health Insurance Portability Act, the privacy regulations. Here, when I'm talking about medical information that can be withheld because disclosure would constitute an unwarranted invasion of personal privacy, what I mean is perhaps if someone wants a copy of my entire personnel file, and within that personnel file, maybe it talks about time I spent out on family medical leave. Maybe it talks about a time that I had a workers' compensation injury. Any information that reflects medical information about an employee or a member of the public that's not necessarily governed by HIPAA, but where disclosure raises privacy concerns, an agency could choose to withhold based on the fact that disclosure constitutes an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld on this ground. Lists of names and addresses of natural persons if that information is going to be used for solicitation or fundraising purposes. This is one of the very, very few times where an agency has the right to request and require that the person who's seeking the information explain why they want the information. It's very, very narrow in scope. So it's names and addresses of natural persons. So I'll use my, time-worn example of dog licenses. Got a local municipality, the city issues dog licenses. So FOIL request is made to the city of Albany for all names and addresses of individuals who have been issued dog licenses in the past 5 years. The agency, the city, can require that the applicant certify that they will not use that information for solicitation or fundraising purposes, and that it will not be shared with anyone else who will be using it for solicitation or fundraising purposes. So if the person who's making the request was going to use it because they, are starting up a doggy daycare, then, and the only reason they wanted the information in the first place is because they wanted to maybe create, create a mailing list. The agency could deny that, the person who's making the request should basically say, I can't fill out this certification because that's exactly why I did want to use it. And then following that, the agency can deny access to the requested information on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Mugshots, fairly recent. I would say like in the past 8 to 10 years, the law was amended to state that disclosure of mugshots could constitute an unwarranted invasion of personal privacy. It doesn't mean that law enforcement agencies cannot continue to use mugshots for valid law enforcement purposes. It's just that if someone makes a FOIL request for somebody's mugshot, and the agency is not required to disclose. I just want to go back for a second because there's new case law relating to the solicitation. It used to be for many years, the Committee on Open Government had offered the opinion that solicitation was about selling things. So for example, if someone, again, wanted to sell their services as, doggy daycare, as a mobile dog grooming company, as, whatever the case may be, they wanted to use the contact information that they received to sell something. That was our understanding of what the term solicitation was supposed to mean. But there's been some recent case law that clarifies, at least based on judicial interpretation, that solicitation does not need to be to sell something. It could just be to reach out to a group of individuals to try to get them to sign up for something, even if it doesn't cost any money. It just could be just trying to solicit information from them. It could be to solicit membership. It does not need to be soliciting money. So I just wanted to point that out. That's fairly recent case law on that subject. There is a new, as of September 4th, 2024, statutory requirement within the Freedom of Information Law that requires that all agencies subject to FOIL are required to develop a policy regarding providing a notification to public employees in the event that the agency is responding to a request for the employee's disciplinary records. So if a government agency receives a FOIL request for an individual's disciplinary records, that agency is required to now have a policy in place about how they're going to proceed with notifying that employee that disclosure is going to take place. What you see up on the screen right now is the sort of the entirety of the statutory amendment. So it's not very detailed. It doesn't include a lot of detail as to when that notification must take place. It doesn't clarify whether it applies to current employees and former employees. It doesn't even really necessarily define the term disciplinary record. So the Committee on Open Government, in response to several inquiries, we drafted an advisory opinion that attempted to basically, we're offering our opinion as to what the legislative intent was. And we did look at the bill memos, and we looked at judicial interpretations. And so we have an advisory opinion that is posted up on our website right now regarding this employee notification requirement. And so if you'd like to look to see what we've said on that topic, it's available right on our website. And if for some reason you're having a hard time finding it, just shoot us an email and we'll send it to you. But it's on the website under new employee notification policy. So we attempt to answer some of the frequently asked questions we've gotten on this topic. Law enforcement. This is the second ground for denial that's going to be common if your agency houses a law enforcement unit, or the police department, and sometimes it's even a civil law enforcement function. So it's a two-part test, and you have to meet both parts of the test. So the first part of the test is that the record has to be compiled for law enforcement purposes. And to determine whether the record is compiled for law enforcement purposes, you have to look to what the record is being used for at the time of the request, not necessarily what it was originally created for, it's what it's being used for now. So the example I give is based on case law, and it has to do with time and attendance records. New York Times made a FOIL request to the New York State Executive Chamber for copies of time and attendance records for a particular employee that was being investigated by the Department of Justice. Executive Chamber said, no, these are records compiled for law enforcement purposes. New York Times tried to say, well, that's crazy. These are time and attendance records. They're not law enforcement records. And the courts weighed in and stated that they agreed with the Executive Chamber that the record is that the time and attendance records at the time the FOIL request was made had been compiled for law enforcement purposes because they had been gathered together by the Executive Chamber and handed over to the United States Department of Justice for a law enforcement purpose. So there is also case law that specifies that the exemption does not apply just to criminal law enforcement investigations. It also applies to civil law enforcement investigations. That's the first part of the test. The second part of the test is whether disclosure would cause one of the harms envisioned by the statute. Would it interfere with a law enforcement investigation or judicial proceeding? If your agency is the entity that received the request, but you are not the agency that is conducting the investigation, you have an obligation to reach out to the agency that is conducting the investigation to confirm whether or not disclosure would cause harm. The second potential harm is whether disclosure would deprive a person of a right to a fair trial or impartial adjudication. Would disclosure identify a confidential source or disclose confidential information relating to criminal investigations? Or would disclosure reveal non-routine criminal investigative techniques or procedures? Would disclosure essentially reveal the combination to the safe? Would it reveal information that would allow a potential lawbreaker to evade law enforcement detection? Things of that nature. That's what this is intended to cover. All right, I can take a little break here and let's see. Someone is wanting to know, municipality regularly purchase real estate and development rights for preservation, recreation, or other purposes from private sellers. To facilitate this, the agency hires appraisal firms to value the property. Are valuation appraisals the town uses for the purchases, such as to make an offer ever? This is a very specific question, and I'm going to, I guess, ask this person to reach out to us directly because it's just a little bit more than I think I want to delve into on a general purpose FOIL training about valuations and appraisals. And we actually do have fairly recent advisory opinions on the subject of information information used, like, for example, for cost comparisons, or that's not the word, comparables. When you have the Board of Assessment review or your assessors using comparables, we have information about that. But I guess for the person who submitted this question, I would just ask for if you to reach out to us directly, because it's a little bit much to dig into. Can FOIL requests from a real estate agency that appear to be in place of a title search be denied? What I have to say about this is, someone is not permitted, a government agency is not permitted to charge higher fees or to treat a request differently just by calling it something else, by calling it a title search. What you need to keep in mind is that anytime a government agency receives a written request for records, where they have reasonably described the record sought. That's a FOIL request. So if someone says, I would like a copy of the certificate of occupancy for 123 Sesame Street, that's a FOIL request. If someone says, I would like copies of any building permits issued for 123 Sesame Street, that's a FOIL request. If conducting a title search goes above and beyond what an agency's obligations are under the Freedom of Information Law, then it comes out of the realm of FOIL. If you're doing more than you would be required to do under FOIL, then go ahead and call it a title search and charge some other fee. But if a real estate agency is essentially just making a Freedom of Information Law, the agency can't charge different fees or handle it any differently just because it's a real estate agency making the request. Someone, I think, included a copy of the PDF. Thank you for everyone. If in the chat, there's a copy of the FOIL information session slides. Thank you. Someone just clarified that they were real estate agencies or title search. The answer is the same. It doesn't really matter who's making the request. Is it a request for records where the person has reasonably described the records sought or not? That's all you look to. Someone has asked whether you can refuse to access. What about public housing law? Can you refuse access based on this? Honestly, I'm not really sure what if there's a provision of public housing law that makes a record confidential, which there may be, then you rely on that statute to deny access. Like, so for example, I'm not as familiar with public housing law, but when I was at OMH, I would deny a request for psychiatric records based on the fact that those records are exempt from FOIL disclosure by state statute, specifically New York State mental hygiene law. If the same is true for public housing law, where there's a provision within public housing law that makes a particular type of record confidential, that's your response to the individual, is that we are denying your request because this record is confidential, is exempt from FOIL disclosure by state statute, and then specifically reference the provision of public housing law that makes it confidential. Someone asked whether security camera footage is FOILable. I always encourage people not to ask that question, and I don't mean to slam on this person because people ask this question all the time. All records are quote unquote FOILable. Everyone has the right to make a request for any record that they want to make a request for. You can make a Freedom of Information Law request for anything. And then the agency has to determine whether it can assert one of the statutory grounds for denial. Maybe it's because that access to that record is governed by another statute. Or maybe it's because the agency is going to deny access because of the content of the record. And that's what's the case with security camera footage. Security camera footage maintained by a government agency is a record just like any other. It's just like a piece of paper or an email or data or a recording. It's a record. So if an agency is going to deny access to that recording of security camera footage, they have to be able to assert one of the statutory grounds for denial. What happens if you send, this is a question that says, what happens if an agency sends the solicitation form, I guess asking the person to complete a form stating that they will not solicit. Someone asks whether you can require that it be notarized. In my opinion, no. Certification does not require notarization. You cannot require a certification be notarized. So as long as they're willing to sign it, then that's all they need to do. You cannot require, an agency cannot require that a certification that the information will not be used for solicitation or fundraising purposes be notarized. Someone says, revising my earlier question, can we refuse access to certain records if they contain the names and addresses of municipal housing residents based on unwarranted invasion of personal privacy? Again, so you're referencing under public housing law too. That I don't know. I'm not familiar with public housing law, but if you're talking about people that they don't own the property. Information relating to ownership of real property is a public record, but if you're someone who's renting through municipal housing under public housing provisions, yes, you may be able to deny access, but you always have to keep in mind that the agency has the burden of proof. When you're going to deny access to a record on some basis, you need to be able to feel confident that you as an agency can meet its burden of proof, can stand up in front of a judge and explain why disclosure would cause the harm. Someone asked, what points are personnel files considered confidential? They're not. There is no general confidentiality provision relating to personnel files. It all depends on content. There's no statutory ground. When I use the word confidential here at the Committee on Open Government, we use that term in a very narrow way. Confidential means that there's a state or federal statute that makes it confidential. There may be privacy interests relating to a personnel file, but unless there's a state or federal statute that makes it so, we at the Committee on Open Government don't use the word confidential. So there is no blanket confidentiality associated with personnel files. It's going to depend on the actual content of the records. Someone asked what qualifies as disciplinary records. As I mentioned, we put together an advisory opinion on the topic. So I'm going to point you to that advisory opinion that's on our website, where we attempt to answer some of those questions relating to the employee notification policy. Some follow-up question is similar. Next question, surveillance security camera footage of town facilities always required to be disclosed. It's a record. You need to review the record and determine whether disclosure would cause harm. Would it endanger life or safety? Would the disclosure constitute an unwarranted invasion of personal privacy? It's up to the agency to be able to justify non-disclosure. Someone says we get requests that include and for anything else you deem relevant. And the person asks me, how do you advise we respond to this part of the request? My advice is that you let the person know that that does not reasonably describe a record sought, and it's not our role to determine what might be relevant to your FOIL request. That does not reasonably describe the record sought, and that's a valid ground for denying a particular part of a request. If an agency sends the solicitation form and the FOIL applicant doesn't respond, you would have to deny access. If you ask someone to complete a form saying that they will not use the information for solicitation or fundraising purposes and they don't respond, you're going to then, as an agency, have to issue a denial of access and give the person the right to file an administrative appeal. What are the penalties for wrongful denial? We're going to talk about that in a little bit. Are the names of people who file complaints, for example, dog barking, property complaints, subject of FOIL, or can we redact their names to protect them? That's a good question. In our opinion, if someone makes a FOIL request, for example, for a copy of the complaint that was made relating to their property, like they know that someone's maybe like filed a complaint with the building department about their real estate, about their property, they want a copy of the complaint. The agency would be required to disclose the complaint, but in our opinion, could choose to withhold the name and identifying details of the individual who filed the complaint on the ground that disclosure would constitute an unwarranted invasion of personal privacy. I mean, that person may fear retaliation, or you just may be concerned in general that if it's our practice to disclose who's making the complaints, it may discourage people from making complaints. Someone asked whether substantiated investigations are subject to disclosure. I'll remind everybody that, again, presumption of access. Unless you can assert one of the statutory grounds for denial, all government records are subject to disclosure. The courts have generally held when there's an allegation of misconduct that has been substantiated against a public employee, then those must be disclosed. If the allegation is unsubstantiated, there is no blanket ground for denial for unsubstantiated allegations. The courts have weighed in on this over the past several years since the repeal of Civil Rights Law Section 50A, which had made police personnel records confidential. In the 4 years since, the courts have discussed this topic quite a bit, and there's no blanket ground for denial for unsubstantiated allegations. The agency is going to need to make the argument that disclosure would constitute an unwarranted invasion of personal privacy of the individual who's the subject of the complaint. All right, going back to slideshow, interagency and interagency material is intended, this ground for denial is intended to protect the deliberative process. So you have perhaps you have draft documents, you have email communications, you have memos that all remain either internally within a single agency or have only been shared between or among multiple state level government agencies. I say state level meaning a federal government agency is not an agency subject to the interagency material protection. Like, for example, there was case law that had situations where the New York State Department of Environmental Conservation was communicating with the federal ENCON. And when the requests for those communications were made, DEC attempted to take the position that they were interagency material, and the courts weighed in and said, no, this is a federal government agency, and they are not an agency as that term is defined by FOIL. But on the other hand, let's say, for example, you have a town clerk has a question about the Freedom of Information Law and emails me at the Department of State with their question, and I respond back in writing with my opinion about whether our particular record could be redacted in a certain way. Those communications are interagency material. You've got 5 town board members all emailing each other, that's intra-agency material. So it's intended to protect that deliberative process. Within those intra-agency and interagency material, what is required to be disclosed is statistical or factual tabulations or data. And the courts have defined this fairly broadly to include any objective information, statistical or factual information, not just numbers. You're required to disclose instructions to staff that affect the public. So, for example, if a particular government agency intends to say to their employees, in lieu of Election Day being a holiday this year, staff may take the Friday after Thanksgiving as a holiday in lieu of taking Election Day off. It's just something general like that. So it's instructions to staff about what days they're permitted to take as a holiday, but those instructions affect the public, because if you have an entire municipality, for example, that is going to be open on Election Day, you've got town halls open on Election Day, but closed the Friday after Thanksgiving, the public has the right to know that. So that's just one example of that, instructions to staff that affect the public. Final agency policies or determinations, such as a finding of misconduct, a substantiated finding of misconduct against a public employee, a letter from Human Resources or a supervisor to an employee indicating that they have been found to have engaged in misconduct, that would constitute a final agency policy or determination that would need to be disclosed. And external audits, including audits conducted by the Office of the State Comptroller. So if the Office of the State Comptroller sends a copy of an audit that is not permitted to be withheld as interagency material, it would need to be disclosed. Let's see. We're coming close. We're doing pretty well. Certification. There are 2 situations in which a government agency is required to provide a certification upon request. And similar to the certification we talked about earlier, someone asked whether they can require that certification be notarized, and the answer was no. The same is true here. The agency, there's no particular form or format. It doesn't have to be notarized. It doesn't have to be any sort of legal affirmation. It's just, it's basically a written promise. I certify on behalf So the two examples are is when an agency indicates that it does not maintain or cannot locate a record, an applicant can seek a certification to that effect. And then the agency would certify either that it does not have possession of the record sought or that the record cannot be found after a diligent search. And all that really needs to be is something in writing saying, I, Kristen O'Neill, on behalf of the Committee on Open Government, certified that we do not possess a copy of fill in the blanks. The second situation is when an agency provides a copy of a record, the applicant may request a certification that the copy provided is a correct copy of the original. So the agency isn't certifying that the content of the record is accurate. They're just saying that the copy that they gave the applicant looks exactly like the original. If the agency has to or chooses to redact a record prior to disclosure, but someone still wants a certification, the agency could say something along the lines of, I certify that this is a correct copy of the original subject to the redactions that I've identified. Appeals. There are two traditional situations that give rise to a right to file an administrative appeal. The first is an express denial or an affirmative denial of access, and that's where an agency possesses a record, tells the person that they possess the record, but that they're withholding it in whole or in part. Constructive denial of access is where an agency fails to respond to a request within the time limit set forth in the statute. So those are the two situations that are specifically addressed in statute. There are other situations that come up that sort of interfere maybe with an applicant's ability to obtain records in an efficient and timely manner, where they might ultimately say, I'm just treating this as a denial of access and filing an appeal. Those are also very factually specific. And we're always available to talk about those types of unusual, weird situations that crop up. But these are the two traditional things. As I mentioned earlier, a statement by an agency that it does not possess the record sought is not a denial of access. The applicant's right at that point is to request a certification to that effect, that the agency does not possess the record sought or it cannot be found after a diligent search. It's not a denial of access. You'll notice that in that first bullet, I talk about a record being possessed by an agency, but it being withheld in whole or in part. Also want to point out a recent advisory opinion that our agency, the Committee on Open Government put out regarding an agency's obligation to redact. I think most agencies have been doing this. This isn't really a huge issue, but there's been some First Department appellate decisions that have given the opinion that have held that if a record contains both exempt and non-exempt material. So let's say, for example, it's intra-agency material. Let's say you've got an email communication that contains intra-agency material, but part of the intra-agency material contains statistical or factual tabulations or data. For many, many years, the court, including the Court of Appeals, and the Committee on Open Government, have either held or offered the opinion that an agency is obligated to, if they want to withhold the portions that they're permitted to withhold, they have to redact those portions and then disclose the remainder of the record. The First Department was taking the position that if the record contains both exempt and non-exempt material, that the record could be withheld in its entirety. And this is just entirely inconsistent with prior Court of Appeals judicial precedent. And we drafted, hopefully, a nice, clean advisory opinion for anyone who's had questions about this issue because they've seen those First Department decisions. It's, again, right on our website. It's one of the small banner items. Please feel free to look through that. So just pointing out again that if a record contains both information that can be withheld, but also information that must be disclosed, an agency is going to be obligated to redact the portions that it's permitted to withhold, except if the record is if access to those records is governed by a separate statute. If the record is exempt by state or federal statute and it is exempt from disclosure by state or federal statute, then there's no obligation to redact. So for example, if someone wants copies of, again, medical records, psychiatric records, those agencies that possess those records would not be obligated to go through and redact names and identifying details from the medical records. They would just withhold the records in their entirety. But if you have records that are interagency or law enforcement and contain both exempt and non-exempt material, you do have to engage in that process as an agency and redact the portions that you're permitted to withhold and disclose the rest. When denied access to a record or a portion of a record, an applicant has 30 calendar days to appeal. The FOIL appeals officer is the head or governing body of an agency or the person or persons designated by the head or governing body. FOIL appeals officer cannot be the same as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the record sought or fully explain reasons for further denial. Sometimes it's a combination of those things. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeal level. The agency is required to send a copy of the appeal and the appeal determination to our office. You're welcome to email those to us. We like email, we like electronic records. You can send us a copy of the appeal and the appeal determination at the same time if you'd like to as an agency. Fees. There are two fee structures under the Freedom of Information Law. The first is for photocopies up to 9 by 14 inches. If someone wants photocopies of a record, an agency is allowed to charge 25 cents per photocopy for copies up to 9 by 14 inches. That's it, end of story, done. That's all the fee that an agency is permitted to charge. The agency cannot charge for this time it takes to search for the records or to the administrative costs associated with complying with the Freedom of Information Law. You cannot charge for the time it takes to review the records to determine rights of access. Those are not reimbursable costs. So for photocopies, it's 25 cents per photocopy, done, end of story. The second fee structure is the actual cost of reproduction for all other records. What are you allowed to take into consideration when determining the actual cost of reproduction? Well, first, the law states that it's the cost of preparing a copy of the record. So sometimes agencies have tried to expand this to preparing the record, and they feel that preparing the record includes the time it takes to redact a record, and that's clearly under the statute and accompanying regulations is not permitted. It's the cost of preparing a copy of the record. So for example, if someone wants records scanned and emailed to them, and your agency has a multifunction copier scanner and you have the ability to scan the records and email those records, if it takes 10 minutes, 15 minutes, 20 minutes, an hour to scan those records, no fee is going to be permitted to be charged because you can only charge the hourly salary of the lowest paid employee capable of preparing that copy, but only if it takes at least 2 hours. Once you hit that 2-hour mark as an agency, you are permitted to charge that hourly fee. So if someone makes $15 an hour and it took them 2 hours to make the copy, you can charge $30. If you need to put records on an electronic storage device, whatever the electronic storage device cost you, you are allowed to pass along to the applicant. If you do not have the information technology, the technological capability in-house to make a copy of a record, like maps or blueprints, things of that nature, audio, video, and you need to send it out to a third-party vendor, whatever the third-party vendor is going to charge you, you have the right to pass that fee along to the applicant. But again, you cannot, as an agency, charge for search or review time. That is not a reimbursable cost. You cannot charge for the time it takes to apply redactions. You cannot charge for the time it takes for an attorney to review those records. Not reimbursable costs. There's something else. Notification in advance. The law requires an agency to notify an applicant in advance of any fees under the second fee structure. It's discretionary for photocopies. I encourage agencies to let applicants know how much it's going to cost for photocopies, particularly if it's a large amount of photocopies. I mean, if it's only going to be 50 cents, it's probably not a big deal. But if you make, you know, make 400 pages worth of photocopies and it's going to cost $100, that's going to be a big deal to someone. And you want to make sure that they're willing to pay that $100 before you as an agency incur the cost. But for photocopies, it's discretionary for the agency. For everything else, like for example, if you're scanning those records and it's going to take 7 hours to scan those records and you're multiplying that by someone's salary, you need to let the person who made the request know how much it's going to cost, at least an estimate in advance. If you need to send it out to a third-party vendor, you need to get a cost from the third-party vendor and let the applicant know in advance what that cost is going to be and make sure that they're willing to pay it. As an agency, you are permitted to get fees up front to make sure that they are willing to pay it. You can get either a deposit or ask them to pay it up front. If for some reason they overpay, obviously you need to reimburse them, but that's information about fees. And I am wrapping up. I promise we'll be right here on time. And then if people want to, if we have more questions, you can stay on while I answer a few questions. The Committee on Open Government does not have enforcement authority. We are an advisory entity. You can call us and you can ask us questions, any questions you want about the Freedom of Information Law, open meetings law, but we cannot force an agency to take certain actions. We do not investigate complaints. Sometimes people contact us and basically want us to send like a dunning letter, a counseling memo to an agency telling them they did something wrong. And that's not really our role. Our role is to answer questions. We provide advice. If you as a member of the public contact us with questions, we answer those questions for you, and you take that information that you've gathered and you bring it to your municipality and say, listen, I've reached out to the Committee on Open Government. This is the information they've shared with us. And you're welcome to contact them as well. If CPL Article 78 proceeding is the enforcement mechanism for under the Freedom of Information Law. If an applicant appeals a denial of access and that appeal is denied, then the applicant has the right to bring an Article 78 proceeding in state Supreme Court. The judge can award attorney's fees and other reasonable litigation costs. It's mandatory when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. Discretionary on the part of the judge when a requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time limit. So that's the end of the presentation. I will go back into questions, but I just wanted to, wrap up in case people had to end and go on to something else. Reminder that anyone is welcome to contact our office by phone or by email with questions, whether you're a government employee, member of the public, media representative, doesn't matter. Our phone number is up on the screen, the 518-474-2518. Our email is COOG, which is our acronym, at dos.ny.gov. For people that are logging off, thank you for joining me. And now I'm going to go into questions. Let's see. Someone says, I've been at meetings where a letter is discussed but was not supplied to the public before the meeting. When I filed FOIL for it, I was told they would not give it to me in 20 business days. This is sort of a provision of the open meetings law to some extent. There's a requirement under the open meetings law that records scheduled to be discussed that would be available under the Freedom of Information Law are supposed to be made available at least 24 hours prior to the meeting, either upon request or if the agency has an active website, it should be posted to the website. Sometimes things come up at meetings that were not scheduled. It doesn't mean that the public body is not allowed to discuss those things. So there might be a letter that was received where the agency didn't have time to get it posted to the website. They're still permitted to discuss it, but again, you did it within your rights to make a Freedom of Information Law request for a copy of that letter. Beyond that, if this person, you have questions about the way the agency responded to your FOIL request, we can take it, offline, but yes, you could make a FOIL request for it. Can the records and appeals officer be the same person? No, we did mention this earlier that the FOIL appeals officer cannot be the records access officer. Body cam footage is a record. I understand it's a pain in the butt record. Someone says, what about body cam footage? Redactions can take days. I get it. Courts have held not a reimbursable cost. It's, I certainly encourage when you law enforcement agencies, when they receive FOIL requests for body cam footage, to try to work with the applicant to try to focus the request to as narrow a time frame as possible. Because I do understand that redaction is a time-consuming process, but it is not a reimbursable cost. Someone says, if prep of records would take significant agency time, may an agency deny a request? This is a very factually specific. I mean, the fact that a request is voluminous is not significant enough. Excuse me. The fact that a request is voluminous is not a basis for denial. There's going to be other factors that need to come into play. Does a request go, has the person reasonably described the records sought? Can the agency reasonably locate and retrieve the records with reasonable effort? And yes, I'm saying reasonable 500 times. And what does that mean? Only a court can say. Does a request go above and beyond what FOIL intended, which is some judicial language that the courts have thrown about? So I don't have a single answer for anyone on these cases. It's always going to be very factually specific. Someone says, if our IT vendor retrieves the data on our behalf, we charge the requester for the data retrieved. Someone says the FOIL requested 2-year email data for a specific topic. It's about what the IT vendor is charging the agency for the time it took them to locate and retrieve the records. In my opinion, this is not a reimbursable cost. The agency chose to use an IT vendor for convenience sake, which I completely understand, but it was not obligated to do so. For example, instead of using the IT vendor, the agency could have gone to the specific employees whose email addresses were subject to the request and had them retrieve emails that are responsive to the request. You can go to Kristen O'Neill and say, Kristen O'Neill, you need to search your email for all emails that are responsive to this request. I would have been obligated as an employee of the Department of State to gather all responsive records and turn them over to the records access officer. This was a fee that was, this was not about copying records. This is not a cost for the copying of the records. This was the cost of searching for the records. It's not about extracting data. It's extracting data is using a database. Emails are searchable by everybody who has an email account. So it is a very different thing. So no, in my opinion, you cannot pass along the cost of asking your IT vendor to perform a task that could have been done by your own employees. Yes, I understand that it was convenient, and if you would like to pay the $370 because it makes everyone's lives easier, that's fine, but that's not a cost that can be passed along to the applicant. An agency denies a request. Is it mandatory to provide a certification that such records do not exist? That's, I've mentioned it a couple times now at this point. That's two different things. There's a difference between denying a request, which is stating, yes, I have the records that you've asked for, but I'm not giving them to you. And here's the reason why. That's a denial of access. A statement by an agency that it does not possess the records sought, or that the records cannot be found after a diligent search, is not a denial of access. That certification only needs to be provided upon request. But yes, once it's requested, it's mandatory on the part of the applicant. The one person with the emails is following up with me saying, we requested the emails from the employees, yet did not receive feedback from the employees. That's an internal problem. That's not the applicant's problem. That's the town or the village or the municipality's problem. You need to get everyone on board with understanding that it's not optional. it's not optional to assist the records access officer in responding to the Freedom of Information Law request. So because you have employees that are not doing their jobs, not doing what they're supposed to be doing, that's not a reason for charging a fee to an applicant for records. So anyway, that's all my questions. People have been saying thank you, so I will say you're welcome to everyone. Thank you for joining me. And if anyone is done for punishment and wants to join me, I'll see you in a couple of hours. Have a good day. Thank you.